The way that restraining orders work is anyone can go to the courthouse, or we have it now online on some of our counties. It's a packet of information that someone fills out, and they fill out a complaint, and in the complaint allege whatever they allege, and then they go in front of a judge. It's called an ex parte hearing. Attorneys aren't there, the other side's not there, defendant's not there, no one's there except the plaintiff, the person that's filing this, and they tell the judge what they want to tell the judge, and then the judge makes findings. The judge can either grant what's called a temporary order, or they can deny it, or they can set it for a full hearing. So those are the things that happen on an ex parte temporary hearing. Once a person has a temporary restraining order in place, or it's continued for a hearing, then the defendant gets served with it, and there's a hearing date. So you have a short time from the date of service to the hearing date usually. It's usually within a few weeks, even less. The statute has a certain number of weeks, and it's a short period of time. So you have to prepare quickly. That is, you have to look at the complaint and see what the plaintiff alleged, and then you have to go through each of those accusations basically and decide what to do with your client. If it's put in place, if facts are found, if the defendant gets up there and there's some domestic violence, it could get even worse. Potentially opens you up to other charges if that's the case. So you have to take a look at all the accusations. If they're not true, you have to combat either with other evidence or with witnesses, or you have to find out what the motivation is and go through all the accusations and be ready for hearing on whatever date it is, which is, again, a quick turnaround. And then when you go to court, the plaintiff has the burden of proof. They go first, and then you cross-examine their witnesses, the plaintiff, and then at the end of that, you hopefully don't have to present evidence, but if you do, then you're prepared, your witnesses are prepared, your defendant is prepared to testify, and at the end of that, then the judge makes a decision whether to grant or deny the motion.